offers unprecedented potential, of course, to improve our lives, starting from health, education, climate change, and so many important issues as well. Yet, as you know, artificial intelligence becomes more and more integrated, but also it presents profound challenges. And those are some of the very important points that you will hear more from the presentation of the background paper today. So before further ado, I know that Rob has done a very interesting introduction to many of our presenters this afternoon, but I'd like to take this opportunity to welcome and introduce Professor Virginia Dignam, Professor of Responsible Artificial Intelligence. I really love that, Responsible Artificial Intelligence, at Umeå University, Sweden, where she leads the AI Policy Lab. Well, she's a leading voice, as Rolf has mentioned before, advising at the Wallenberg Foundation, and also the co-chair of the IEEE Global Initiative on the ethics of autonomous systems, and chair of the ASEF Technology Policy Council. I have a very impressive long line of CV, and I want you to just bear with me, everybody. She's a member of the expert groups at UNESCO, OECD, and also part of the EU's high-level expert group on AI, and the UN's United Nations high-level advisory body on artificial intelligence, and the World Economic Forum Global Future Council on artificial intelligence. I can go on, but let me take this opportunity to also welcome Dr. Rachele Carli. I hope I say it right. Or Rachel, in a more popular way. Rachele is a postdoctoral researcher in the Responsible AI group at Umeå University as well. So her research mainly focuses on highly interactive AI systems and the legal, social, and ethical implication of the design, development, and dissemination of these technologies. Those are very important matters indeed. Prior to her postdoctoral position, she completed a PhD in law, science, and technology at the University of Bologna, and a PhD in computer science at the University of Luxembourg. You've been here and there, Sure. So obviously that strengthened her interdisciplinary approach on the team and in the research, and her doctoral work investigated the theme of deception and manipulation in human-agent interaction. Oh, I need to hear more about that. With a specific focus on the re-evaluation and protection of human vulnerability in the digital age. And last but not least, I hope I say it right, Dr. Tang Yingxia, the Deputy Director of the Human Rights Research Center at the Nankai University, a national human rights education and training base, and an associate professor at the School of Law in Nankai University. She holds several key roles, including the council member of the China Society for Human Rights Studies and expert member of the Rule of Law think tank of Tianjin government. So her primary research focuses on international human rights law with extensive expertise in digital rights, business and human rights, something that I also work personally on that, and climate change law. So ladies and gentlemen, please give a warm applause to our distinct panelists this afternoon. And Professor, you have the floor for the presentation of the background paper.
Thank you all for being here, and of course thank you the co-authors or the main authors of this background paper, which I have the pleasure to start the presentation today. So it was a couple of months ago, sometime before summer, that Army contacted us asking if we would be interested in working on this report. My background has very little to do with human rights, but fortunately Raquel is since a couple of months in my group and she knows all about it. So I dared to accept the challenge. And of course we have been supported by the invaluable expertise of Tang on the Asian and the China aspects that are in the report. I believe that the report has been shared with everybody, so you might have had time to have a look at it. We are now going to give a short presentation on what is there, and mostly we would like to engage in a discussion after the presentation with all of you. I hope the slides work well. We'll see. Yes. So the report is divided in a couple of sections, mostly 3 sections, besides a general overview, of course. One is we really tried to identify and analyze the different ways at which human rights are being identified, protected, used or ignored within the approaches at the different regions, Europe and Asia, but we also looked at the global aspects that are being done at the global and international level. So that's the first part of the report, which Raquel and Tang will be presenting in a minute. Then we moved into a deeper dive into the thematic focus of this meeting, the ones which we are going to discuss tomorrow on the working groups, and we tried to provide some type of background on what has been happening in terms of privacy and data protection. So what are the risks, what are the issues there, what's happening, what does it mean, equality and non-discrimination in the age of AI, and also what kind of remedies are being addressed by the different regions, and how access to justice, and apology for the typo, are there. And finally we have also a section on recommendations and future work which we propose as a call for action for all of us. The purpose of what we did is simply to map what has been there, to look mostly at and trying to compare and to analyze what are the different starting points which therefore lead to different approaches and different understandings in Asia and Europe. How can we learn from each other, and with some aim to create or to provide the basic and the starting point for a discussion with all of us on what are actionable pathways for a rights-based AI governance. So what does that mean? How can we do it? And what kind of concrete actions all of us in our own capacities and in our own regions can do about it? AI and human rights are kind of, I tried to put it as politically and diplomatic possible. There is a dual dynamic here. There is kind of, in one hand, we can use AI to support human rights. We should, like we in the different keynotes just before, we should really ground AI on human rights, but more often than not, we are also seeing the tension between what is being developed and achieved with AI and what we would like to see in terms of the protection and the governance of human rights. So both, we can see both the roles of human rights in this context as a normative framework that guides the AI development. So if we would want to develop an AI system or to use an AI system or to deploy an AI system, we should be able to use human rights as a kind of a touching stone to see, is this system that we want to use or develop, how does it align or not with human rights? But at the same time, we can also see the development of AI as tools to support and to encourage and to guide the implementation and the governance and also the realization of human rights across the world. And again, what we have talked in the different keynotes, there is this fake tension between regulation and innovation, in which the most important is to realize that without the regulation, we really cannot push innovation in any direction that supports this balance and ensures that the balance is in the right format. So I would like now to give the floor to Raquel to talk a little bit about global frameworks. Then Tang will do on the Asian ones, and then Raquel again will do the European ones.
So we will go very briefly on this slide. In general, we can appreciate at an international level many initiatives to protect human rights and to foster their inclusion in the discourse around the governance of AI. Of course, the idea that we get from this very rich body of norms and principles is still a very fragmented background. This is due surely to the power of international law that cannot impose strict regulation that be uniform for all the countries around the world, but it is surely something on which we should work collectively in order to guarantee a better enforcement of human rights in the AI discourse. So now we can move to the focus on, yes, the protection of human rights in Asia.
Thank you again. Asia is as a frontier region for the implementation of AI technologies and governance exploration. Exhibits unique technology dynamism and institutional diversity. AI is a powerful deliverer of economic growth and social innovation, but it also brings new ethical and human rights challenges. That's why central goal of AI governance in Asia is to strike a balance, promoting innovation while ensuring it remains responsible. Countries such as China, Japan, and South Korea not only excel in Asia in AI research and application, but also demonstrate richly diverse approaches to governance. In the Asia section of the background paper, we adopted a focused and comparative research strategy, conducting an in-depth examination of the three representative cases: South Korea, Japan, and China. Our analysis is guided by four core dimensions grounded in international human rights norms and regional instruments. First, we look at legislative models to see whether countries are adopting binding laws or leaning on voluntary guidelines. Second, we assess the governance structures to determine if authority is centralized within a single body or decentralized across multiple agencies. Third, we evaluate how clearly fundamental human rights are like privacy, like non-discrimination and access to remedy are integrated into the very fabric of AI rules. And finally, we scrutinize the enforcement mechanisms, examine what forms of oversight, penalties, or incentives are put in place to make the rules effective. By systematically and comparing the interlocking mechanisms between their AI governance frameworks and the human rights principles, we aim to identify divergent practices and common trends across the region regarding to the issue. South Korea's AI Basic Acts seek to establish a comprehensive legislative framework guided by human rights principles, but the framework may lack flexibility to deal with new and unprecedented risks emerging from the development of AI. Japan's AI Promotion Act emphasizes agile governance and multiple stakeholder collaboration. enjoying soft norms to foster industrial science reputation. However, its success will depend on how effectively these principles are translated into practice and whether the soft regulatory approach can adequately address the complex questions posed by AI. China addresses specific human concerns arising from technological advancements through specialized regulation on algorithmic recommendation and generative synthesis. Asian experience demonstrates that technological advancement and rights protection are not zero-sum games, but complementary, mutually reinforcing processes. In addition, by exploring the AI development strategies and regulatory objectives of China, Japan, Singapore, Malaysia, Indonesia, and other countries, as well as their specific approaches to safeguarding human rights from AI-related risks, we have also outlined the future strategy of human protection in the field of AI across Asian region. Overall, the AI governance model emerging from Asia is a distinctive blend of policy guidance and ethical self-regulation. It balances the progressiveness, regulation of active technology collaboration. In summary, Asia's regulation framework emphasizes flexibility, innovation, and state-led development models, forging a stark contrast with Europe's legally binding human rights protection approach. This divergence underscores the importance of Asian-Europe dialogue. Europe can provide enforceable human rights safeguards, while Asia can contribute effective regulatory innovation models. I think that's all. Thank you.
All right. Can we give a big round of applause to them? Oh, yeah. Okay. All right. Sorry. It's the Asian part. Apologies. My fault. My bad.
So, if we now turn our attention to the European context, that here it has to be understood with its geographical sense, not institutional sense, we find a large body of regulations. Here in this slide you can notice just a very few, small selection of those that is still relevant to try to understand some common traits. So first of all, of course, we have to mention the General Data Protection Regulation. That is a pioneering text for many different reasons, but for the sake of our argument, it's important to underline that it recognized data protection as a fundamental right to be distinct from, even if of course connected to, the right to privacy. And then it introduces the concept of risk to rights and freedoms of natural persons, paving in this way the way to a much stronger right-based but mostly risk-based approach to the assessment of the AI impact. Then we have the Framework Convention on Human Rights, Democracy and the Rule of Law, that among its many merits as the one to challenge the very spread technologically neutral approach to AI, replacing it with a system-specific approach and a context-specific approach to risk management. Then we have the human rights, democracy and the rule of law impact assessment that, following the Framework Convention, also adopt a socio-technical perspective on the analysis of the impact and consequences of the use of AI. And of course, finally, the AI Act. Maybe no one can see the slides anymore.
Fatima will help us with that.
It's okay.
Talk about AI.
And that, of course, is very well known to be the first ever regulation, attempted regulation of AI, and is also, it became also the, we may say, emblem of the risk-based approach regulation, even if, as we saw, the root of this risk approach to governance and regulation of AI has much older roots. So, I already changed slides, but it's fine now, it doesn't matter. So, from this brief introduction, we can already grasp how the trend is moving towards, first of all, regulation, and second of all, a regulation that is risk-based and risk as a central role. And this is largely due to the fact that largely due to the fact that the logic of product safety regulation that is on the foundation of many of these initiatives was and is already well known among producers, developers, companies in general, and so the idea was that to create a framework of regulation, we, based on this logic, may have made it more easy to implement, to operationalize this new approach into existing procedures, and also could have fostered the acceptance of these regulation. Of course, with these come also a substantially problematic point due to the fact that the logic of risk and the logic of human rights actually belong to legal, evaluative, and thematic dimensions that are inherently misaligned among each other. And the main reason is that risk belongs to the realm of what is measurable, quantifiable, valuable in a very objective way. We could, and we normally do, set a threshold below which risk is considered acceptable, sometimes also welcome, in order to gain what is considered higher benefit or a higher profit. But the same reasoning cannot be applied to the discourse around human rights, because human rights belong inherently to the realm of what is inalienable, what is universal and strongly relational, especially. With these, we can notice also another problematic, potentially problematic trend, that is the over-reliance on harmonized standards that by definition are technical tools, very often predominantly drafted by large corporations and by technical experts, claiming for very technical requirements, and all of these dynamic is far removed from the democratic procedures that normally underline the lawmaking. So just to very briefly wrap up, of course, we have a much stronger tendency towards regulation, what we call hard law or black letter law in the European context, regional, once again, context, even if also this approach comes with large focus on the need to interpret these rules in order to make actionable what they claim for, while in Asia we still have legal architecture still more focused on guidelines, principles, and ethical values, and still less, even if possibly developing legal and regulatory, strictly regulatory approach.
Thank you so much both, and now very quickly, because our time is also, we want to leave plenty of time for the discussion, just a little bit more about what more is in the background report, so the issues around the thematic focus. I will not go at all very much on this, because that tomorrow we will be discussing the thematic focus in much more detail, all the three different themes. But what I would like to point your attention is to the work that we have done, for instance, identifying what are global or general sources of privacy harms as they have been understood in European and in the Asian context. The paper says much more about this, but it's just a short overview. Then the same way we looked at the thematic focus number 2, the equality and non-discrimination. Privacy harms shouldn't be there, I think. That's something in anyway, the privacy and non-discrimination. Again, there we looked at what are potential sources of bias, where this bias can come from, and we also looked at trying to look at how is bias and issues of bias and non-discrimination being addressed in the European and in the Asian context. Again, I'm just showing you the slide, and tomorrow in this thematic focus we will be discussing these issues in more detail. And with the third thematic focus on issue of remedies, so how are regions addressing the ways to solve or to remedy the issues. Again, here we looked at, for instance, what are barriers to access to justice, so how easy it is to complain about what AI has done or not to you. And we have looked also, again, extensive comparative analysis on the different regions, and also looking at what's happening globally or international level. And I just want to finish with a couple of slides on the way forward, or on the recommendations that we describe in the paper. So I think that, as has been said in the keynotes and before in this session, there is a general understanding that ethical aspirations are very important and add a fundamental role to be talking about, and to old sessions like we are doing in these days, which 10 years ago would not have been understood or possible to be held. So the ethical part, and understanding that there is an ethical component to the development and use of AI, has been very important, but it's time to move to something operational, to something enforceable in one way or another, to looking at not rights just as part of the design of the AI systems or of the behavior of the AI systems, but mostly as seeing the issue of human rights as a component that needs to be taken into consideration across the whole life cycle, from the very first question, should we use AI, to the ways and the methods and the possibilities and the technologies, the deployment, the oversight, and so on. So it's not something that it's part of the AI as a product, but much more of AI as a process. Issues of the need to strengthen and support multi-stakeholder participation in this type of dialogues and interventions. Ensure that there are enforceable and usable and easy to use impact assessments that support this continuous evaluation. And finally, that we really look at the regulation, and especially human rights-based regulation, as essential to build the trust and the legitimacy of all these systems that we are building. So the opportunities that we could consider for cooperation between Asia and Europe is to maybe looking at Asian-European Observatory of AI and Human Rights, what's happening in all the different countries and all the different regions, develop some type of training for regulators and judges that support them in understanding also what AI is, and maybe even more importantly what AI is not. And it's not a magic thing that it's doing everything and anything. Looking at how can we ensure and at least some type of translatability between audits and certifications that are appearing in many different regions and countries. Understanding to have some type of maybe informal standards for what we mean by fairness and the remedies, creating some dialogue platforms, and together really creating a force that is really leading globally across the world in a rights-based approach to AI governance. And I think, yes, we finished.
Okay. Thank you very much. Thank you. And of course, a big round of applause has been given. And This is an amazing presentation about the background paper that we are having at this point to be, of course, discussed further tomorrow in depth. But then now it's time for us to have comments, questions, observations from the floor. And if I may, I'd love to walk around as well. I think it's good. I see some hands coming on the right side and the left side. We don't really have much time, so I hope that you can briefly introduce yourself and go straight to the point on your comments or questions. And of course, after this, we're gonna have another panel discussion. So we'll start with the gentleman on the right side.
If you make questions that can be answered yes or no, that we have a very short answer.
I know. We have to have enough time for the panelists as well. Yes, please.
Hi there. I'm Choi from ASEF Asia. Sorry, it's not a yes or no question, but one question is at the global part of the presentation. Can you also share a little bit in terms of from the existing human rights mechanism? So, for example, the Human Rights Council under the International Covenant on Civil and Political Rights. Are you seeing efforts to try to expand the scope from the human rights mechanism side to cover the AI governance bit as well? And then the second question is, do you see a tension between some of the legal understanding of the technology versus the technical understanding of the technology? For example, explainability in the AI Act versus some of the technical field like interpretability, the limitation of that.
Okay, thank you. Shall we take another questions and then get back to you, Professor? And yes, the gentleman in the back.
Yes, thank you very much. Alexander Kriebitz from the Technical University of Munich, Institute of Ethics and Artificial Intelligence. Actually, I have two questions, like within the presentation and before in the discourse we have heard several terms, such as human rights, fundamental human rights and fundamental rights. And I would like to know how those terms are defined, because in international space, we have like different scopes within those terminologies. Apart from that, there has been made a statement in respect to bias on one side and that implying a human rights violation. I think within the context of statistical bias on one side and discrimination law, we have also different terminologies, because statistical bias can arise for many different reasons which are not covered by discrimination law or the interpretation of the principle of equality according to human rights law. So I would like to have a bit more, perhaps like further comments on those 2 points. Number one, in a way, the terminology, human rights, fundamental human rights, fundamental rights, and on the other side, the intersection between bias and also the perception of that being equal to non-discrimination or discrimination.
Thank you. So I have one more question before I give it back to our panelists today. Yes, please.
My name is Hans Ottosano. I come from the Danish Institute for Human Rights. I'm emeritus, retired by now, but used to work as a senior researcher. In the course of the spring, I was conducting a review of the human rights situation in 5 Asian countries: China, India, Indonesia, Malaysia and South Korea. And what I saw, and I did that review trying to see the trends between the 1990s up to 2022. And what I saw was that, well, with the exception of South Korea and with some exception of Malaysia, I saw a pretty bleak situation with respect to human rights protection and respect in most of the countries. So my question is the image that you have been presenting here a little bit too rosy? And in order to ensure accountability, which we talked about in the previous session, would the Asian countries need a much stronger civil society and much stronger mechanisms of accountability? Thank you.
All right. Thank you very much. So we have three gentlemen asking various questions regarding human rights, about legal standing, as well as the mechanism in Human Rights Council, and so on and so forth. I think you have also noticed that, Professor. So I give the floor to you, as well as Rachel, as well as Tan.
Let me start with the last one, and then I will give opportunity for both of you to answer in more detail the more technical legal parts. Answering the last one, it was not our aim nor our mandate to evaluate the human rights situation nowhere, not in Europe, not in Asia, nowhere. So we were not tasked, and also don't have the capabilities as far. I don't. Maybe you guys have, to evaluate the human rights situation in any country. What the mandate and what we looked at is looking at what are the governance mechanisms, the strategies for AI in those countries, how those are or not aligned with human rights in its global perspective. So not looking at what's happening in human rights in any of the countries, but looking what are the intentions, the aims, the regulations, the frameworks that have been developed in or proposed in all these countries, and how these ones align potentially with human rights. So your question is very valid. It's not something that we looked at.
So I started taking notes too late, so I think I forgot. So the first question was related to if they cover also, or they try to be prepared to cover also issues related to AI. But then there was another question, because the answer to this is pretty quick, but there was the second question.
Legal standing and implementability.
Okay.
Legal understanding and technical understanding.
Yes, right. Okay, that's good, because the second was more elaborate. So the first one is a yes or no, I would say, answer if you want to be quick, and the answer is yes, surely. Of course, even if these international instruments were developed before AI became a thing and such an important topic of discussion, but now they are really, and also at an international level, we perceive the urgency to act and to try to either reinterpret or also modify some of the initiatives and texts in order to be prepared to cover the impact at the social, legal, ethical level of AI systems. With respect to perception, unfortunately, still today there is a very big gap between the understanding of legal experts of AI and the understanding of technical experts of AI. More than understanding, because of course technical experts have more skills to understand this topic, but I would say the perception. So sometimes from a legal point of view, it's very essential to define clearly the object of your analysis in order to be able to try at least to produce a valuable regulation, or even to interpret correctly the norms that we already have. And this is, generally speaking, still missing, not completely. We are working on this, but sometimes, as also Professor Dignum was saying, there is a very magic understanding of AI, or overly negative understanding of AI that is still not a good approach, because if we are just scared, or if we consider something inherently evil and that's the end of our deepening of the concept, is very difficult to produce an effective regulation, and of course it's very difficult in this field, more generally speaking. And this leads also to the topic of terminology. So terminology is another very big issue, especially because legal terminology has some specificity, and the technical terminology as well, and sometimes the same word means different things. With respect to human rights are those encoded and claimed in the Universal Declaration of Human Rights. With fundamental rights, normally we refer to what was absorbed in the European level and the European Declaration of Human Rights. And of course, it's the two body of laws are and rights are somehow overlapping, but in a sense, at European level, we surely have, probably more instruments that are more encoded into the European regulation in general and AI regulation, and so we have more instruments in order to try at least to foster and enforce them better, I would say. Yeah.
I want to add a point. I think this is the last question about the technology. Yes, technically, when we speak of human rights, I think it's a global or universal concept. It's not only legally concept, but also ethical or other kind of concept. But when we talk about fundamental human rights, it's kind of legally term, yeah. And usually in constitution context, we call it fundamental human rights. So I think that's the difference, yes, between these two concepts.
Did we miss any question?
I think it covers all. And then I know time is not on our side, but do we have some flexibility to have another round, Army, or so we continue with the next one?
Final question.
Maybe one final burning question for this session of the presentation of background paper. Any ladies? I haven't seen ladies asking. We have all the ladies in the front, but yeah. Do we have one? Okay. Yes, please.
Thank you very much. I'm Cecilia Hevstveit from Norway, the Norwegian Institution and the Norwegian University of Technology and Science. Now, thank you very much for the presentation. I was just wondering about terminology again. How have you circumscribed against the national security exception? Because unlike other areas of human rights, there is a national security exception in the European legislation, in the AI Act and in the Framework Convention. How have you dealt with this? I haven't really seen it in the background paper, so I was just wondering if you could give us some reflections on that particular issue.
Thank you. May we directly have some comments as well as sort of like a wrap-up remarks from the three of you. Thank you.
So I think we try to maintain a general approach to the discussion and to try to, because the focus was mostly on a regional, meaning geographical level, and so we try to include as much as possible the approaches of the regional or versus global approaches. So we didn't have a very detailed and specific approach to this.
Again, here in the same way that we answered the question on the quality of human rights in different countries or not, we looked at what are countries doing on their AI strategies and how that aligns with the Declaration of the Fundamental Human Rights as described in their own legislations. Most countries and most regions, like you know, kind of separate civil and military use of AI. AI Act in itself ignores completely. So we followed the same approach because the question was, how are these regulations, this approach, these strategies addressing human rights? So we also didn't comment or we didn't went into a reflection about this military versus civilian uses in the same way that we didn't look at how well or not human rights are being upheld in European nations and so on. So in a sense, it's a very unsatisfactory answer, I do agree, but it's time, yeah, it's something which I think we can discuss definitely on the different working groups tomorrow, but we tried to stay within we didn't color outside of the lines, let's say. We could have done, but we stayed with the rules.
Time to have something Sure. You are welcome to do so.
And I think it's perfect about the European part, but as the Asian part is highly fragmented, yes, in Asia, and legislation, policy, the practice. So I just do the desk work. I didn't have the field study and even have the chance to go every countries to know what is the legislation and policy going on. So I think it's open for us to discussion in the following days. And if you have something to add, it's very welcome. Thank you.
All right. Just a quick addition to that before we hand over to the next one. On the gentleman's question regarding what the UN has worked on this, especially Human Rights Council and the OHCHR, something that we've been following closely as well. I think it's good for you to see the report of the OHCHR from 2024-2025. There is a specific report on the digital age. It has many salient points in there. And if you notice that last October, we have a joint declaration of many of the special rapporteurs on freedom of expression, highlighting artificial intelligence and sort of like developing conducts and guidelines. So I think we are on the right track. Not perfect, of course, but it's a long way. This is the road that we have to go through. And tomorrow we're gonna continue the discussion on that. And with that, I think, do you have anything else to say, Virginia, Rachel, and that? If not, a big round of applause for our panelists. And I would like to take this opportunity to welcome the next moderator. Our next moderator, Rika Frank Jorgensen, I hope I've said it right, the acting head of research from Danish Institute for Human Rights, who will be chairing the panel on AI in the public service.